All right, well, welcome everybody. Thank you. I'll try not to bore you or overly frighten you late in the day. Thanks for coming. As Theresa was saying, I'd like to thank the bank for having me give a talk. What I always like to say is, if you have an attorney you're really happy working with, or hope to work with another, and any of this sparks something that makes you think, oh wait, I need to update what I've done, or I need to do something I haven't done. I see this partly as a chance for me to help people, but also as a chance for sort of public service. And even if you don't come to me, if you go to your attorney and get something done, that will have been a successful outing for today. Very briefly about me, I've been in the area 20 plus years. My wife, Carrie Secrest, lives in the area. We have 2 daughters in college, one of whom graduates next month, if all goes according to plan. Very happy to be done with 1 tuition payment. And I've been doing primarily estate planning for about 20 years since I moved to Vermont. For years, I also did a lot of real estate closings, and then I've stopped doing that. My partner, Amelia Darrow, she's wonderful, she's fantastic. She and I just do estate planning. And there aren't many people in the area who do that. We have a large percentage of the probate matters that are currently, I think our office has the large majority of probate matters currently before the court. We have a great relationship with the judge and the court, and we also do, as I'll talk about, a lot of long-term care Medicaid planning, which for most of us is the biggest threat to our finances. So I'm going to spend some time really because nobody knows that, and what information people do know is usually wrong, but that's probably a good thing because there's a lot we can do in Vermont that we can't do in places like New Hampshire. Is anybody here a New Hampshire resident? Oh, okay, well, I'm admitted in New Hampshire. If you go to a nursing home, try to stay on this side of the river. We're more likely to be able to protect your assets. Any other questions before I get started? So feel free to, as we go, if you've got a question, people raise their hand and say, I have a friend, and I'm happy to answer questions, or if I think it's something we'll cover later, we'll try to just make sure we get back to it. All right, so going in the right direction. This is going to be a very quick coverage of a whole lot of information, and I actually have things to hand out here. If you wouldn't mind just passing those around, and just collect them at the back or something. At the end here, you'll hopefully remember a few key points that are most important to you, and then if you want to follow up on anything else, we're happy to meet with people. So the 3 basic documents of an estate plan are durable general powers of attorney, advance directives for health care, and last will and testaments. One of the things I'm going to be harping on today is that if all goes according to plan, your will should be absolutely useless. And that is because, a lot of people come to me and say, I'm all set because I have a will. The problem is wills only control where probate property goes, and I'll talk about what is and isn't probate, at the end of the long, very painful and often expensive and always delayed probate process. The probate process is the long-established court-supervised process to allow your will, to give family members or others a chance to contest it, to make sure creditors get paid, the credit card companies, all of that, to give Medicaid a chance to get their money back if they've paid for your nursing home care. And at the end of that year, or however long it can be a little less, it could be a lot more, the court issues a final decree saying, okay, here are the beneficiaries who get your stuff. We can have that happen much more quickly if we don't go through probate, and if everything passes outside of probate, the will isn't going to do anything, and there's nothing for an executor to do. We'll talk more about that. Yeah.
So, get this right. If I hire you, we do everything right. My goal is to avoid probate.
That should be everybody's goal.
Because I did it recently with my mother.
Ah, yeah.
No probate.
Yeah, yeah. Did it take a long
That's the
time?
goal, right?
That is my goal. I think
My goal.
surprisingly, a lot of attorneys I find aren't focused on that as a goal, but I really have a hard time thinking of a time where it'd be helpful to go through probate, unless maybe you know everybody's going to be fighting anyway, and suing each other, and then you've got a ready-made venue. But we try to avoid that in the first place. So yeah, probate avoidance is important. You still need a will, even if we do try not to have any assets pass through probate. Two scenarios. One, which is the most common, is you forget to deal with, meaning put in trust or name beneficiaries on your checking account at the bank, and then when you've died and your kid comes to the bank and says, Theresa, I've got the death certificate, hand me the money. Teresa says, well, come see us in a few months after you've been appointed by the court. So there are ways to avoid that. Sometimes you add one or more children onto the account. That can work well. It can also backfire in less common situations. I had one matter where years ago, daughter was my client, and basically there was nothing in the estate other than an $80,000 checking account. Daughter lived with mom. Daughter had been put on the account. Was it supposed to, and then it was jointly owned with child. And then when mom died, child legally owned it. It doesn't go through probate because it was jointly owned property. So sister said, well, wait a minute, what about my half of the rest of mom's money? My client said, no, mom wanted me to have this. And we went to court, and ultimately my client got to keep the money. So it can work, but we have to be thoughtful about how these things are done. You also don't want all your bank accounts or any other accounts to go to a jointly owned child right as they're starting to divorce, because you can imagine that problem. Advanced directives for healthcare, very important. Also, names, if you're incapacitated, your healthcare agent. And then durable general powers of attorney, often among these three documents, are the most important, because the durable power of attorney says if I'm incapacitated, and sometimes even if I'm not, here's my agent who can talk to the bank and make decisions about my money and pay my bills and all that. If somebody has a stroke and somebody needs to pay their bills, or even just deal with the bank or deal with insurance companies or anything like that, if there is no agent named under durable power of attorney, often the only way to get access to those funds and that information about what the funds even are is by going through a court-supervised guardianship proceeding, which takes months, even in an emergency, and is just a nightmare that can almost always be avoided with durable powers of attorney. So, critical documents. Yep, so I talked about that. Advanced directives for healthcare. People often say, well, wait, I have a power of attorney, and they think they have a power of attorney for the finances, the durable general power of attorney, but what they actually have is a power of attorney for healthcare, naming your decision maker, and then the living will says, pull the plug, don't pull the plug, kind of. These are now basically, they used to be separate documents when I started practicing. They're now collapsed into an advanced directive for healthcare. Of these, the most important piece is naming the decision maker if you're incapacitated. Because the living will, it's very hard. You have to be squishy in that language and the legal documents, because who knows what you would or wouldn't want in different scenarios. But as long as you name the agent and trust them to make any decision for you, that's the most important legal thing you're doing. And then I've been telling clients a lot this recently. Pretty much everybody, almost everybody, thinks they have a DNR, a do not resuscitate order, when in fact all they have is an advanced directive for healthcare. So your advanced directive for healthcare may have that squishy language. If I'm unable to think or care for myself, I want only care directed to my dignity, and authorize my agent to decline all treatment, including artificial nutrition and hydration, the primary purpose of which is to prolong my life. Doesn't really tell you anything. So if you're at home and you're 98 and you would not want to be revived, and you have a heart attack, unless you have a DNR on the refrigerator, and unless you have that in your hospital chart right when something happens, no matter what this lawyer's document, this advanced directive says, they will violently revive you unless you have this medical order, the doctor signs it, that says make me comfortable if something happens, and then really it has to be sort of in front of people's faces for rescue then not to start CPR and just to make you comfortable. I said we want your will to be useless. And am I shouting at you guys for too loud? I'm never sure. I'm very close to you, so I don't want to like overwhelm you. Okay, sorry. I'll try not to breathe on you.
I can't hear.
So I said wills ideally should be useless, other than a couple scenarios. The other scenario I didn't mention is you die and there's a wrongful death lawsuit brought. That has to go through probate, so then the will pours over to the beneficiaries or to a trust. But young families, it's where you legally name guardians for minor children upon your death or incapacity. So, the Brady Bunch scenario, they each had kids from a prior marriage. And if you provide, this is the kind of scenario where it absolutely makes sense to try to plan. Because I think we've all either seen or heard of stories where, Mrs. Brady dies, gives everything to Mr. Brady. Mr. Brady finds a new wife or just decides he never really liked her kids anyway, and everything skips her kids. So there are ways to plan around that with trusts or with beneficiary designations, and you can do it in a really fair way that crafts a pretty good balance, often depending on a whole lot of circumstances, between providing for a surviving spouse and providing for the kids of the first to die. So there's ways of doing that. Prenuptial agreements are another way. You can protect against that kind of in a second marriage scenario with kids. So I talked a little bit about probate property, talked about the importance of avoiding probate. The best way of describing what is probate is saying what's not. So there are basically three categories. Anything that's jointly owned property. So if I own my house jointly with my wife, one of us dies, there's no probate of my half of the house. It's automatically owned by the other. If we both die together, or eventually at the second death, if we haven't planned around it, then it gets stuck in probate. And that means that nobody will be able to list the house for sale for 3 or 4 months until the executor gets appointed. So there are different types of jointly owned property. Probably the most common, you'll see joint tenants with rights of survivorship. That would typically be a bank account, for example, or a joint brokerage account. There's tenants by the entirety, which is, if you're married, probably how you own your home. It's a form of joint ownership. One of you dies, the other gets it, but there are creditor protections built into that for married couples, where if one spouse gets sued for killing somebody in a car crash, if they hold the property as tenants by the entirety, then they can't sue, they can't attach any part of the house. John, I don't know if your staff knows this, but Vermont is one of the few states in the country where you can have your bank accounts here owned by a married couple as tenants by the entirety, which provides creditor protection. We've done that sometimes with doctors, for example. It's a way you fill out the signature card. All states will let you own real estate that way. Vermont's one of the very few that allows you to own personal property, money, that way. And then tenants in common, sometimes, let's say I own a home like a camp with my, I moved to Vermont from DC, 20 some years ago. And I had all these clients at the beginning, all of whom had camps. And I was thinking, wow, all these people have these children's camps. There must be children's camps everywhere. The whole cabin thing just didn't occur to me. Different language. So tenants in common means if I own with my brother a camp, a hunting cabin or something, and one of us dies and we don't own it jointly, we own it as tenants in common, my half goes through probate and then doesn't automatically go to him, but maybe goes to my kids. Maybe that's what you want, maybe you don't. And you can avoid probate by using a trust, but it's something to look at if you own real estate with people to look at the deed and see exactly how you own it. Sometimes people will own, I've seen tenants in common between a boyfriend-girlfriend or a longtime partner, and then they get married, but they never change the deed, and sometimes that can cause an unnecessary probate when it's supposed to go to the other.
John?
Yes?
What if you have a second home? Can that be tenants by entirety?
It is with a married spouse, with a spouse.
You have your primary residence, and then you have a second home. So it'd be good to put the second one in there entirely.
Depending on your circumstances. I mean, if you have trusts, you would want to use the trust instead, probably. So, and then so one category that avoids probate is jointly owned property. But at the death of both parties or all the joint owners, unless you do something, it ends up in probate. Anything that has beneficiaries, designated beneficiaries on a retirement account, in trust for, which is, or TOD or POD, transfer on death, POD is pay on death. These are all just beneficiary designations for different types of accounts. And, life insurance, IRAs, bank accounts. A lot of people, we end up opening a lot of very small estates for just a checking account because dad owned it. Dad was the sole owner. He never added a kid as either a beneficiary or a joint owner. When he dies, it gets stuck in probate. And I've basically had clients to decide, if it's going to cost $3,000 to deal with a probate estate and there's a $3,000 bank account, just walk away, let it, default to the state of Vermont. But you can now name beneficiaries with the bank here on all of your bank accounts. And that could be kids, that could be a trust. And that's always something we try to focus on to make sure that those don't cause a probate estate.
What about the IRAs?
So most people for their IRAs, when they set them up, they'll have beneficiaries, like spouse, children, others.
Brother, yeah.
And so that would pass to that person. It's basically a contract. No probate if that person is alive at the time of death. And then depending how that form gets filled out, one of the drawbacks of, and I think this is my next slide, there are some risks with beneficiary designations that just require you to sort of pay attention to it. So for example, there's a phrase per stirpes, 2 words, PERSTIRPES, and that's usually a box that you check on like an IRA form, for example. And if you name your brother and then you check that box per stirpes, that means if your brother predeceases you, his share passes to his kids, if any. And if he doesn't have any kids, then it just goes back to the others. But now, if he's the only beneficiary you've named, now you've got a problem because it's unclear what happens to that. Does it go to his probate estate? Does it come into your probate estate? So these are just red flags, which is the kind of thing that, when we're working with clients, we just go account by account through everything and say, well, how about this? Who have you named as a beneficiary? And really make sure that it is the way you want. So what I was just talking about, these non-probate transfers, beneficiary designations, for example, in particular, you don't need to pay a lawyer. You just do it. It's quick, easy, cheap, but you can forget it. You can, I've had situations where somebody named their wife on a life insurance policy. Years ago, they divorced. They never changed the beneficiary. Guess who gets the life insurance policy when they die? The wife. So you have to be careful about it, and it can skew an overall transfer of an estate. So I try to talk clients out of, in most cases, giving one account, naming one child as a beneficiary on one account, and naming another child as beneficiary on other accounts, and just setting it up all that way. Because then you got to remember which is the inheritance for which kid. And you could end up cashing out all the accounts that are supposed to go to one kid or one person, and they get nothing, and all the other money's been shifted over, or real estate's been shifted over to the other kid, and say they're not talking when you die. It's a problem. So, a better approach often is to just, on every single account, if you decide you want, 40% of your assets to go to one individual, on every single account that you have, name them as a 40% beneficiary, and then you don't have to worry about it so much. A lot of people say, well, if I know that if I add a child as a joint owner on my deed, it'll avoid probate at my death, which is true. But the problem is, if you add them and then they get sued or they filed for bankruptcy, your half of that real estate is subject to their creditors. Or they get divorced. Now half of your property, your real estate, is part of their divorce. And I've had clients have to buy out the in-law they never wanted their kid to marry in the first place out of their own home. So, and then sometimes, I've seen kids just basically become estranged from their parent. Now they're a half owner of the property, and the parent sometimes has to buy them out because the kid can force a sale legally. I had that happen once, and the family just came to me and just couldn't figure it out. Why would this child, who's always been just such a loving child, ever do this? And it was awful for a period of months. And then they figured out later the child had the beginnings of brain cancer, and it totally changed their personality. But anyway, so there are real risks to this. I've had times where I've done it, sometimes against my advice, clients have done it, or if it's a day before somebody's going to die and we quickly just need to do it. But in general, we try to steer clear of that because there are some better alternatives in most cases. It also, adding a child onto your deed or adding them onto almost any kind of property starts a 5-year look-back period for Medicaid. If you need Medicaid within 5 years of doing that deed, you've given potentially half of the value as a gift to your kids because you made them a 50% owner. If you're have a stroke and you need long-term care Medicaid will say, well, wait a minute, you gave away $250,000 of gifts in the last 5 years. You're not eligible for Medicaid. Isn't this fun?
So that was mainly on deeds, like real estate, like your house.
Right.
Not the IRAs and the life insurance.
But it applies to those just as well. So IRAs, you can only be the sole owner. So for IRAs, it's only a question of beneficiaries. But if I have a brokerage account at Park Place, for example, and I add my kid onto that account so it'll avoid probate at my death, some bad things can happen. All those things I listed could happen, right? In addition, there can be negative tax angles because there's something called a step up in tax basis. If I've got an account with a lot of Apple stock that I've had since Apple started, and I sell it the day before I die, I'm going to pay capital gains on all that growth, capital gains taxes. If my child sells it the day after they inherit it from me, or spouse, or anybody, all of that capital gain disappears. And it never gets taxed. The problem is if I add that child as an owner on my brokerage account, I've transferred for half of it my original basis. So if they sell it the day after I die, they pay no capital gains on what they inherited from me at my death, but they do pay my original capital gains on what I gave to them. So
same with the house.
Yep, same with the house. Yep.
Okay.
Unless they live in it for 2 years as their primary residence. Probate process, just try to avoid it, please, whatever you do. It's just a pain. So trusts. Trusts are a great way for many people to avoid probate. It's sort of a revocable trust is sort of the most comprehensive estate planning tool for the large majority of people for accomplishing what you want while avoiding probate. The downside is it costs more. You pay a lawyer more money to set it up. And a lot of times with clients, I'll say, look, you've got one big choice ultimately. Do you want to do beneficiary designations on all the accounts, and we do this deed for the house? Or do you want to do a trust? And the trust is more expensive. And some of them go with the beneficiary designation, and then they just understand that they kind of have to keep on top of it a little more. And if a child dies, they have to, change the beneficiaries, and just keep an eye on it. So a trust is, if you do a trust, it basically replaces your will, and everything you think an executor would do following the terms of your will, the trustee does, which could be a spouse or a child or anybody, does it by following the terms of the trust. Pay bills, distribute out the assets, make charitable donations or whatever, but it's all outside of probate. It's all outside of the court.
Is there a big price difference?
There is. Yes and no. It's usually a few thousand. Yeah. But not like 10,000. So a trust is like a box that can hold assets. And I don't know if people are familiar with with LLCs, right? Any of us can set up an LLC. We're the owner of the LLC, and that LLC can own assets. You could put a house into it, you could put money into it, you could put trucks in it or whatever. But I'm my LLC. Basically, it is me. It can be under my social security number. But then anything in that LLC is treated differently from what my personal assets are because it's protected for liability and other reasons. It works in many ways the same for a trust. So if I set up a revocable trust, I can be the trustee of my trust. The tax ID number of the trust is my social security number. It's really just me. But I can put my real estate in the trust. I can put non-IRA bank accounts into the trust and investment accounts. And then anything in that box, I have total ownership and control of everything in that trust while I'm alive. Upon my death, I don't own anything in that box. My trust owns it. And so everything in the trust avoids probate. And then the trust document says, when I've died, give everything to my wife, if living, otherwise equally to my kids. And there are a whole lot of other scenarios that you can cover very elegantly in a trust that you can't do with a beneficiary designation. If a beneficiary is on SSI or Medicaid, their share, because they had a stroke or something happened, or they've got special needs, or they're never going to be good with money. And I've seen that, over time. A trust can hold their assets under various circumstances with somebody other than them, the trustee who maybe is the trustee after me, paying out money as they need it. So my trust for my wife and me and our kids says, until they hit 30, if we've both died, the trustee pays for whatever they need. But then at age 30, maybe they get half of the trust they have the right to take. And then maybe at age 35, they get all the rest. So, they can learn how to manage money over time. And some of this stuff, there's a big difference. We have clients who have almost nothing. We have clients who have a whole lot of assets. And a trust isn't right and the expense isn't right for everybody, but for a lot of people, it fits. It really is the optimal solution. So somebody who has 5 kids and they don't get along all that well, we can have the house end up at the death in that trust rather than ending up, there's a deed I'll talk about called a ladybird deed where you can basically name all 5 kids as beneficiaries. But then that means the moment I've died, all those kids are equal owners of the property. They all have to agree on absolutely everything. Whereas, with a trust, you can do that same deed to a trust and then just have 1 or 2 children make all the decisions. They're required under the terms of the trust to treat everybody equally, maybe. But it's their decision. They're the ones driving the decision-making process. So they might have a $200,000 house and that's all, but that might be really the appropriate solution for that house. So living trusts, if you have a trust in a will, it's almost always a bad idea. I see that in New York a lot. John, you were in New York, weren't you? Yes. The only reason I can think of doing a trust inside a will is so that the New York attorney who charges as a percentage of assets gets his huge payment, because I can't think, because if a trust is in a will, it has to go through probate to get there. Life insurance trusts, we do that for larger estates. Special needs trusts, we have a lot of clients with grandchildren or children who have drug and alcohol issues, or special needs. We can set up a trust so that maybe at my death, that child's or beneficiary's share doesn't go to them outright because they can't manage it and because they would lose benefits if they tried. They lose SSI and Medicaid, maybe Section 8. And we don't want it maybe going to a child because maybe that child really, it's a sibling. It's too burdensome for them to deal with all this for their sibling who they're annoyed about. And that's not fair. Who is a burden to them in terms of managing this stuff. So you can have that beneficiaries' share go into a special needs trust, and then the trustee, under the terms of that trust, is allowed to pay for anything the government doesn't pay for. So if the kid needs a new car, you can buy a car in the name of the trust. If the kid needs a house, you can buy a house in the name of the trust. And the trustee, whoever that is, and you've got options, professional trustees, family members, friends, the trust owns those assets, and as long as it's managed carefully, it can provide a lifetime of funding for that beneficiary without causing them to lose any benefits. And then a Medicaid asset protection trust, we'll talk about this a little more in the Medicaid world. Under some circumstances, if you have enough assets and you're worried about protecting them from nursing homes, you can set it up in a trust that allows you income stream off of those investments, but protects the principal to pass to the kids at your death. So. Advantages, avoids the expense and delay of probate. If you have real estate in more than one state, please consider a trust, because if you die and real estate's just in your name, every state where there's real estate has to have an entirely separate probate proceeding. Trusts are private. Wills are technically public documents, although I don't know anybody who's actually gone to a probate court and asked to see the file, but they could. It avoids court supervision. There are some tax planning benefits with trusts under different circumstances. And it's also a chance. The hands from the grave was my attempt at sort of describing, my daughter's not getting whatever they're going to get on their 21st birthday. Because if you name them as beneficiaries, that's what happens sometimes at age 18. A trust is the only way for them to not get whatever you give them beyond age 21. And then the con is just it's more expensive to set up a trust. IRA suggestions. So much of most people's assets now is in their retirement accounts. And so just you have to just keep your beneficiaries in mind. If you haven't looked at them forever, just check, make sure. A lot of people will name a spouse, but never a successor, a contingent beneficiary after spouse. So, then everybody gets surprised when, mom has died, dad died before, and mom never named the kids as beneficiaries or anybody. Then bad tax things happen and it ends up in probate. You can consider naming charities if you're charitably inclined. It's a great tax-effective strategy for avoiding tax and benefiting a nonprofit if you're inclined to. Because, a lot of times people will say in their will, for example, or a trust, they'll say, okay, I want X dollars to go to this nonprofit and Y dollars to that nonprofit, and the IRAs go to the kids. The thing is, when the kids inherit the IRAs, unless they're Roths, they're going to pay income tax on that. So the charities get the post-tax dollars. When charities, don't pay tax anyway, they get the money, the cash out of the will, and the kids get stuck paying the tax on the retirement accounts. If instead you were to name the nonprofits as percentage beneficiaries of even a portion of an IRA, those go directly to the nonprofit, and then when the nonprofit sells those shares or whatever, nobody pays tax on that because they're a nonprofit. So that frees up more money in your will or trust that's tax-free to pass tax-free to the kids. So there's some fun strategies you can play with here. And if at age 73 and a half, you're required every year thereafter to start, how am I doing for time? Okay. No more questions yet? Because I love hearing myself talk, but yeah.
Is it possible for a person to set up a trust without having to hire a lawyer?
You can do all kinds of things on your own, and I don't recommend it. People ask me that question, can I just do this all on myself? And it's probably a bad analogy, Dan. So the example I sometimes give is you can fix your car yourself, but if you do it wrong, you're going to probably know pretty quickly if you did it wrong. Whereas by the time you figured out that you did something wrong with the trust, it might be too late to deal with it. And honestly, in most cases, it's not the drafting of the documents that's the hard part. It's spotting the issues and figuring out what makes the most sense from a tax standpoint. I mean, almost anybody can write a will. It's possible, but difficult to screw up a will. But like, you shouldn't be using a will in the first place as your primary estate planning tool. That's the kind of example, I give for that. So yeah, you can do it, but I think it comes with risks. And I think it often comes with missed opportunities to do it in a much better way. So.
I was wondering if you should update an old power of attorney now that you said that two things are combined.
For healthcare. That's not, the hospitals and institutions will generally accept one that's ancient. Theresa, how old is a durable general power of attorney before you, the bank, for finances, before the bank starts having concerns that it might be what some banks call stale, which this bank doesn't, but which isn't a legal term, but it just means it's so old the bank's not comfortable with it?
It varies significantly, and I think in Vermont, certification.
The law changed in the last 2 years that banks can actually have some liability for refusing to accept a duly executed power of attorney form.
Yeah.
So we can't really pick a date on that, but we have to use our judgment, and we do have an additional document, an agent certification form. So when in a situation where just the agent approaches us and the principal's condition is unknown or is not even a current customer, and they're saying, hey, I need to open this account in this person's name on their power of attorney, we will have them sign off on several points on that agent certification just to provide us a layer of protection for this document that we don't know how valid.
Yep.
We see them that are typed on typewriters,
Uh-huh.
coming out of New York City. I mean, there's every possible scenario.
Yeah, and the powers of attorney thank you. The powers of attorney create real opportunities and real problems sometimes, because so there's on this new Vermont statutory form you're talking about in accordance with the statute, there's a line where you can give your agent the authority to change your beneficiary designations. And you might think, oh my God, well why would I do that? That's such a broad power. If I'm relying on beneficiary designations for everything, they could give everything to themselves or wreak havoc. So here's a scenario where usually I say, well, do you trust this person you're naming as agent not to steal your money and not to abuse it? And if they say, no, I'm not sure, I say, well, first let's pick a different person. But scenario I've seen happen several times is husband and wife, husband dies, and properly named wife as the beneficiary on his retirement accounts and maybe other things as well. So now, wife inherits these accounts, takes the bank or the institution 6 months if it's Wells Fargo, don't use Wells Fargo, it takes them a while to roll everything over. So now, mom is the owner of that account. Mom has dementia. The beneficiary designations on dad's forms don't apply anymore, but now somebody needs to name new beneficiaries on that. And if mom can't, and if the kids maybe as agent under power of attorney don't have the ability because that piece wasn't initialed, it ends up in mom's estate. And not only does it then go through probate, but you lose, I kind of say bad tax things happen. The kids have to take it all as taxable income or whoever. I keep saying kids. I hope people who don't have kids don't hold that against me. It's just a common way of looking at it. When kids inherit an IRA, they have 10 years to take it out now. They have to take it all within 10 years. If it goes to an estate, they have to take it all in 5. And anything coming out of a non-Roth IRA is taxable income. So all of a sudden, you've doubled their required income over that 5-year period and or increased their taxes. So that's just an example, and that's why these powers of attorney are so important. So enough said.
I got a question.
Yeah.
So you use the word durable power of attorney, and power of attorney, is that the same?
It is.
Okay.
It's technically called a durable general power of attorney.
Okay.
Durable because it endures even beyond your incapacity or through your incapacity. In the ancient common law of England, you had to specify that, and if you didn't, it was an ordinary power of attorney that wasn't durable.
So I just recently lost a brother, and his son was power of attorney, and my brother had a bank account only in his name.
Yeah.
So when my brother was alive, the last few weeks, his son, power of attorney, was able to access that money. As soon as my brother died, power of attorney was no longer in effect.
Right, it stops at that
That's
point.
it. The money's tied up in probate.
Yep.
That's what happened.
Yeah.
Now, if he had his son on that bank account as, jointly, then there wouldn't be a problem.
Wouldn't be a problem as long as those other things I talked about, don't happen.
Right.
And ideally, if he had all the kids as beneficiaries on that bank account or a trust as a beneficiary.
Just a joint account. Like with me and my mother, I was I was a part of that account. So
Yeah.
when she died, I didn't have.
Like I said, it usually works,
Yeah.
but there are times when it doesn't. And that's why I really, if somebody's already done it and it's a $5,000 bank account, I'm going to say just leave it. It's fine. If it's a $50,000 bank account, I might say, well, let's take your child off, because there's two reasons people add kids often as joint owners of bank accounts. The first is so that if they become incapacitated, the kid can pay bills. But that they'll be able to do with a durable general power of attorney, and not just at the bank, but anywhere. They'll have access to funds. The second reason is probate avoidance, but that can be solved with beneficiary designations without making your kid an actual owner of your money. So, yeah.
When you work with clients, do you generally recommend doing a trust, but also doing the power of attorney at that point?
Yeah, it's typically all the suite of documents you do. And then clients who, and there's a lot of them who don't do trust. There's oftentimes when it's just not worth the expense of a trust. We will almost always do a power of attorney.
And the reason that I mention that is because we see an increase in people suffering from dementia or some type of cognitive impairment. And when you start getting to that point where they're not able to engage in those conversations, it gets really challenging to put those things in place. So, I always recommend do it sooner versus later, even if you never touch it for 20 years or whatever.
Yeah, thank you. And 99% of the powers of attorney we don't require that there be what's called a trigger, where the doctor has to come in and certify, because sometimes it can take ridiculously long to get a doctor to certify that someone's incapacitated. So typically, I say, if you trust your agent, let's have it go into effect now, and then your child or whoever can step in, or spouse can step in right away if needed, or if you have a stroke the day before you sell the house, and they don't need to spend a week trying to track down a doctor. So these are like really the nuances of planning, but it's another example of sort of a thoughtful approach, things that an attorney should be asking you about or talking to you about.
John, just one question.
Yeah.
If dad has a will, then...
If who has a will?
If dad would have a will, then the child would get the money, obviously, right?
At the end of the probate process. But as I was saying, a will only says who gets probate property months or years later at the end of the probate process. Our goal is to have nothing go through probate, so the will doesn't do anything.
Goal, no probate.
Yeah.
And is probate expensive?
It can be. In some states like New York and California, the attorneys somehow get to charge a percentage of assets, which can be insane. Vermont, lawyers are ethically barred from doing that, which is, I think, the right answer. But a lot of times, it's more the aggravation in most cases. I mean, a probate estate, most of the probate estates we do, if the family's not fighting, it's somewhere in the $2 2 to 5,000 range. So not the end of the world, but you can't sell the house for a few months. You can't do anything. And everything you do, I want to sell the car. You have to get the court's permission. I've got clients with kids living abroad. Photocopies, the court won't accept photocopies. We need to get original documents notarized at the embassy in that country. It's called apostille, and then they have to FedEx them, or it's just a tremendous hassle, and it's slow. Yeah.
We frequently will have people come in and they'll say, well, my mother had a will, and unfortunately, we're not attorneys, so we're not able to read the will and make the decisions about what should happen with those accounts. So that's why the will goes to probate court, and probate court is the attorney that deciphers the will and appoints the executor based on the will and all of that. So, and it can take weeks, it can take months, so.
Typically months. Yeah. So I want to talk for a quick minute about Roth conversions, because I'm really recommending this to a lot of clients. And how am I doing for time? All right, you're getting like 20 years of law in under an hour. So do people know, I'll tell you what it is anyway. So two types of IRAs in general. There are regular or traditional IRAs, and there are Roth IRAs. Traditional IRA, I'll call it a regular IRA, you get a tax deduction. And by the way, I'll just call them retirement accounts, right? Because 401ks, 403bs, any of these retirement accounts, where you're the owner, you name beneficiaries. With a regular IRA, you got a tax deduction when you put the money in. It's never been taxed. It's now growing, not tax-free, but tax-deferred. At 73, government says you have to start taking amounts out of them, and the older you get, the more those amounts are as a percentage. And I've got clients with really large IRAs who are so angry that by age 80 that they're being forced to take this money they don't want or need and pay tax on it. And then when you die, your kids have 10 years to take that money. If it's a fair amount, they don't want to take it all in year 10 because it will have grown a lot, but then it's all taxable income in 1 year, so they get slammed. By contrast, a Roth IRA, you don't get a deduction when you put in, but once you've put in, because you didn't get that deduction, it'll never be taxed. The rest of your life, it grows tax-free. When you die, if you're married, your spouse gets it, the rest of his or her life, tax-free. And then when spouse has died, the kids now can let it be, not touch it, for 10 more years of totally tax-free growth before taking it all year 10 in tax-free money, which can be an insane, this is decades of tax-free growth. It is a wonderful thing. What you can do every year is what's called a Roth conversion. If you have a few $100,000 in an IRA, you can take a certain amount this year and roll it over into your existing Roth or a Roth you start. You pay tax on that, on whatever amounts you roll over. So if you got a few $100,000, you wouldn't want to do it on all of it because you'd be bumped into this huge tax bracket. But if you can, in December of this year, if you'll know pretty well what your income probably is going to be for this year, you look at it and you say, how much can I roll over as taxable income and still stay in a pretty low tax bracket, like a 24% seems to be the maximum sweet spot. You pay tax on it, it never grows, it'll never be taxed again. So there's a lot of my clients, and there's a sweet spot for this, which is when your income has dropped, like after you retire, but before 73 for many people, because at 73, your income's going to go up. And you're going to be, and so that means you can cram less in a conversion into those lower tax brackets. So if this sounds at all appealing, talk to your, read up on it. There's a lot out there if you just Google it. Talk to your financial advisor, talk to your accountant. It can be a really nice thing to have and a great gift for the family if you don't end up needing that money. If you do need the money, it's nice at age 80 to have a pot of money that you can take tax-free to pay for a new roof or something. All right. Moving along. Did I cover all that? Yes, I covered all that.
I never heard about that 10-year that you have to, if you inherit an IRA.
It used to be, not that long, that's only a few years old. It used to be that you could draw out, if like I inherited an IRA from my mother, and I got to be able to spread it out over the rest of my life.
Yeah.
The government wanted its money sooner, so now it's a 10-year cap.
So when did that happen?
About 5 years ago, maybe 6. Yeah. Federal estate taxes. If you have more than 13.99 million at your death, you get hit with a federal estate tax. Come see me if that's a problem. Otherwise, and it's a real tax, 40%. Spouses can double up. There's complex planning to minimize or avoid that. Vermont estate taxes are the bigger threat for some of my clients. That's only a $5 million exemption, and spouses can't double up. So if at the first death, I give $3 million, which would be nice to my spouse, and then at her death, she's got $6 million. Our kids, when she dies, pay $160,000 in estate tax to Vermont. But you can effectively double this $5 million exclusion with the use of standard trusts. Gift taxes, people get this wrong all the time. People think, so right now you can give $19,000 to any one person. If you're married, you can double that basically, meaning each of you can do that. People think, well, if I go over that amount, I'm going to pay tax, or my kids are going to pay tax. Until you give away 14 million in that manner, nobody will pay tax. It's just that if you go over the 19,000, you got to file a form with the IRS. And adding a kid to a deed is a gift. So now we get to the juicy stuff. Everybody still with me? We are covering a lot very quickly, so thank you for your patience. Long-term care Medicaid. Medicare does not pay for a nursing home. Medicaid pays if you're eligible, and you might be eligible sooner than you think with some careful planning. So if you, I'll give the husband-wife example again. Husband and wife, husband has a stroke and has to go in a nursing home because she can't take care of him at that point. Then hopefully they would come to me because they're, to toot our own horn, my partner and I are two of only about 30 lawyers in the state of Vermont who do a lot of this Medicaid planning. The rules are ridiculously complicated, but there is great opportunity to save funds in Vermont for a Vermont facility, for a Vermont resident in a Vermont facility. So in that scenario, one of the couple is in a nursing home. Nursing homes around here are running about $160,000 a year. The equity in our home up to $730,000, our primary residence only, does not count as an asset. So the resource limit on a husband and wife, or a husband and husband, or a wife and wife, if one is in the facility and one is at home, is $157,000. That means that together, there's a snapshot on the date of the Medicaid application. We can only have $157,000 in countable assets. The house up to $730,000 is not countable. So it can't be rented, but we can put a caretaker in there, some tricks there. You can each have a car, you can each put $10,000 in a burial fund. IRAs, we get a lot of people who've been rejected by Medicaid, and sometimes it's as simple as their IRAs weren't being drawn down. So your IRA of any amount, if you apply for long-term care Medicaid for both husband and wife if they're married, counts against that $157,000 unless you set the IRA to pay out a certain amount every month, and the person who's in the nursing home has to give that to the nursing home. But once you've set that up, and especially if you're not 99 years old, it's actually not that much every month that you have to take out. Most likely you can preserve the rest of the IRA to pass at that person's death. So once you've done that for the IRA doesn't count against the 157. So I talked about this earlier, this 5-year look-back period on gifts. That's a big problem for a lot of people. If you apply for Medicaid, they don't want you giving Warren Buffett giving away his billions and then applying for Medicaid to cover his nursing home. So they'll look back on the last 5 years of Warren's assets if he had no assets at that point, or very little. So basically with Medicaid, you can't gift to anybody, even charity, but you can spend. You're fine with spending for yourself, you just can't gift it. So actually, I've read stories about people who need nursing care, not skilled nursing, but kind of assisted living, and they just go live on a cruise ship for a couple of years, because they got a doctor on board, and all that spending is fine. They just can't buy a ticket for somebody else. So now we come to one of the best things and least known things that you can do, which is the ladybird deed, also called an enhanced life estate deed. So remember how I said that the home, your primary residence, is excludable as an asset. It doesn't count when you apply for Medicaid. When you die, however, and the house goes through probate, if it goes through probate, Medicaid will come after it if they've paid for your nursing home care. The great thing in Vermont, whoops, there I go again. Glad my kids aren't watching this, hopefully. There's this ladybird deed. People don't know how it got that name. There are different theories. But here's how it works, is basically if we can figure out how to not gift the house to the kids within the previous 5 years, but have it avoid probate, we can save the house in Vermont. And the reason for that is it doesn't, so let's say I do a deed, let's say I don't have a trust, and I have 2 kids, and I say, I do a deed saying, I hereby give my house to my kids, but I reserve for myself all ownership and control while I'm alive, including the right to sell it and keep all the money, the right to deed it back to myself or to anybody else. I've effectively named my children as beneficiaries on the deed itself. Now, it does 2 things. First, at my death, does it go through probate? No, it avoids probate. Secondly, does it trigger that 5-year look-back period when I do the deed? This is a trick question. No, because it's not a legally complete gift, because I can just redo the deed anytime I want. So people who we've done this with will come back 6 years later and say, well, the house is safe now, right? Because the way and what I say is it's not safe because it's been 6 years. It's safe because we've set it up to avoid probate when you die, and Medicaid in Vermont only comes after your probate assets at your death. So they look in your probate estate after you've died, they say, oh, the house isn't here now, and so the house goes to the kids by virtue of the deed.
What if you put the beneficiaries as the trust?
If you have a trust, that's typically what we do, because there are a lot more advantages in terms of covering if-then scenarios. If a child has died at that point, that the trust covers elegantly, which mere beneficiary designation doesn't. Or the example I gave a little while ago of, you've got 6 kids and you don't want them all to have equal owner decision. You do the ladybird deed to the trust.
So if you didn't put this in a ladybird deed and the spouse was in a nursing home, they would come at the nursing home would come after to be reimbursed.
It's not the nursing home. It's that when the house goes to Medicaid to probate, Medicaid would seek to cover.
This wouldn't be in probate because it's under a trust and it's in a ladybird. So
right.
You don't even have to worry about that. How many houses can you put in a ladybird deed?
An unlimited number, but it really, for Medicaid purposes, it only protects your primary residence.
Okay.
But it can be, if you don't have a trust, it can be useful if you've got that camp we talked about and you've got your house, you do a ladybird deed for both to the kids, and you don't need a trust to avoid probate for the camp. So it doesn't trigger a 5-year look-back period. Yeah, so we covered all this except, the downside, or one thing to remember, is you can't sell the house if mom or dad goes into a nursing home, because it's protected with the ladybird deed, but if you sell it, all that money, because the house is still owned by mom and dad, all that money comes back to them, and now they've got way more than $157,000. Or if it's just one of them, they're only allowed to have $2,000. Was the other figure. If it's just one, if there's one individual unmarried applying for long-term care Medicaid, they can only have $2,000 in countable assets. They could have IRAs, which we protect. They can have the house protected with a ladybird deed. But in terms of pure cash, it's going to be harder to protect stuff. And one other thing I'll just say, I actually didn't put it on my slide because maybe it's too much to cover. Even if somebody has a few $100,000 or any amount in excess of the $157,000, there's kind of a complicated promissory note where we can even save that money for a married couple. And I won't go into the mechanics of it, but Vermont lets us do that. And when we apply for Medicaid, everything we do is disclosed to Medicaid. It's all legal. A quick soapbox lecture. Not a lecture, but people sometimes, as they're listening to this, I realize some people are saying, well, that's kind of unethical lawyering, right? This whole like shelter your money so the state covers Medicaid and covers the nursing home. And my quick response to that is, I do a lot of really complicated trust and other work, tax planning for multi-millionaires, and that's considered good planning, right? Not giving it to the IRS and therefore not giving it to the government. But I've got a lot of clients who've maybe played by all the rules and they've saved up a few $100,000 in a house, and and they don't get a good diagnosis like lung cancer after 20 years of smoking, where Medicaid will cover all their costs. They get a bad diagnosis of dementia. Why are they morally obligated not to use the laws in a way that they're allowed to bankrupt themselves and not pass anything on to their kids, when this has been a policy choice by the government? They've had a run of bad luck, and they're just playing by the rules the way the multimillionaires and billionaires are. So I feel really good about this type of planning and helping people this way. So on that note, final thoughts. Life insurance, well, don't have time to go into that, but if you have grandkids maybe who are young, tell your kids the most important legal thing you can do, more important than a will or almost anything, make sure that the parents, your kids or in-laws, have decent life insurance, probably term, not life. The disasters that happen are usually financial after one death, so that can be a lifesaver. I talked about why I hate do-it-yourself software. Selecting an attorney, my advice would be to pick somebody who does this a lot, does primarily, if not exclusively, estate planning. It's just, the more you do it, like anything, the more you see and the more you think of and the more you can help clients. I'll end there. Whatever you leave at your death, let it be without controversy, else the lawyers will be your heirs. And that's our firm. So thank you very much for listening. And